Thanks to Audible for keeping Legaleagle in the air.
Don't call me a liar.
Oh, you're a liar, all right.
And the bailiff tackled them. Hey Legal Eagles, it's time to think like a lawyer. Today we are covering one of my all-time favorite legal dramas. It is The Rainmaker starring Matt Damon. This, I think, will be the first time I have seen this movie since becoming a lawyer. I think it has been over 10 years since I've seen this movie.
I'm nervous, real nervous.
I'm really hoping it stands up to the test of time. I remember it being really good. So of course, be sure to comment in the form of an objection, which I will either sustain or overrule. And stick around until the end of the video where I give The Rainmaker a grade for legal realism. So without further ado, let's dig in to The Rainmaker.
Well, before we can file the claim, I need all three of you to sign this.
Where's Daddy coming in?
Well, he said he wasn't. Some days he comes in and some days he don't.
Well, this is a contract.
What's in it?
Oh, the usual. It's standard language. It basically says that y'all hire us to be your attorneys, and we take care of the case for you. We handle any expenses that we might have, and then we get 1/3 of any recovery.
All right, so this is what's called a retention agreement, which is something you rarely see in the movies, but it is something that is absolutely ethically required to be able to actually represent people. It lays out the terms of your engagement, and it lays out the terms of your compensation as well. And the contract that is being signed here is a fairly standard one for plaintiffs working on contingency. The plaintiff's attorneys will pay for the costs, which can sometimes be very, very expensive in terms of filing fees and experts and deposition costs. And then if there is any recovery at the end, the plaintiff's attorneys will get 1/3 to say 40% of what is recovered. You might say that that is a lot of money, especially when you're sometimes dealing with thousands or millions of dollars, but the plaintiff's attorneys take on a huge amount of risk. They might be out tens or hundreds of thousands of dollars or thousands of man-hours to work up these cases with no guarantee that they're going to get anything. So that is the trade-off when you're dealing with contingency work.
Well, why does it take 2 pages to say all of that?
Yeah, lawyers, man, they're the worst.
No wonder I'm dying.
Donnie Ray has leukemia, and his medical insurance denied him a bone marrow transplant, which would have provided relief to his condition. That's the point of this lawsuit.
For the record, my name is Leo F. Drummond of Tinley Britt, counsel for great benefit. And I say, if this young man has passed the bar exam, Your Honor, let him argue the case. We welcome him to big-time litigation.
You have no objection, Mr. Drummond?
If it please the court, I would be honored to introduce Mr. Baylor to the practice of law of the great state of Tennessee. Judge, you can give him the oath right now, and I'll be pleased to stand for him.
That's actually not just a formality. Usually, in order to stand for the oath of office, you have to be sponsored by a practicing attorney. This is such a good scene because you have this big firm lawyer who knows he's getting a huge advantage by getting this greenhorn attorney, and rather than getting a continuance or dealing with another more seasoned attorney, he is offering to sponsor this young man to take the oath of office so that he can, litigate against someone that doesn't know what they're doing. Kudos to John Grisham for writing this, and kudos to Francis Ford Coppola for the way that they staged it. It's so good.
Mr. Drummond, you've objected to the fast tracking of this case. What's the problem?
Well, Your Honor, this issue's already been ruled upon by Judge Hale. The preparations required, fast-tracking the case, place an undue burden on both parties, I believe.
Nonsense.
Nice.
Let me ask you something, Mr. Drummond. As a defense lawyer, have you ever agreed to the fast tracking of a lawsuit?
Well, Your Honor, I believe I have.
Fine. Give me the name of the case and the court it was in.
Fast tracking, by the way, is a thing that exists in lots of different jurisdictions. It doesn't have a consistent meaning. It depends on what particular court you're in, but often cases will have different tracks based on how complex they are and the need for any due process here. And given that there is a young man who is dying of leukemia here, you can imagine that fast tracking would be very, very important to make sure that all the necessary discovery is taken before he passes away.
How about next Thursday afternoon?
Great for me, Your Honor.
I'm sorry, Your Honor.
That's a week from today.
I believe I'm out of town. Yes, I am out of town Thursday.
The deposition is set for next Thursday afternoon at 2 p.m. Sorry if it inconveniences the defense, but God knows there's enough of you guys to handle it. Now, what's next?
So I have actually seen a judge make a statement almost identical to that. It is one of the disadvantages of showing up to court with a whole army of attorneys. Sometimes I've been on the side of the army and sometimes I've been on the side of just one person. But when you show up with multiple people in court and you claim that your schedule doesn't allow you to participate in certain things, the judge will just look at all of the other people that are at counsel table and say, well, if you're not available, then one of these other people will be available to take care of it. So that's one of the issues when you show up with a whole bunch of other co-counsel.
I'm looking at a team of lawyers who are pulling down $1,000 an hour, and I hate them. From their lofty perch, pissing down on the whole justice system with disdain. I used to hate them because I wasn't good enough for them. Now I hate them for who they represent and what they represent.
Your Honor, how are you?
Fine, sir. Hope the dogs didn't startle you.
Do this thing outside.
It's a little cramped inside. Just have a seat here.
So it would be very unusual to hold a deposition outside just because, you know, you're in the elements and it's hard to do, but it would not be unusual at all to have a whole bunch of attorneys on both sides to participate in one of these central depositions in the case, especially when you're dealing with toxic torts where you have lots of different companies and they all have counsel. You might have 30 people in a room participating in the deposition.
Hey, Donnie Ray. You've already met Judge Kipler.
You would also definitely want to record the deposition testimony with a video camera as they are doing here. There is an added cost, of course, but it is so important to be able to see the intonation and the facial expressions of these important witnesses when they're giving their deposition testimony. What is really, really unusual here is that the judge is participating in the deposition, sort of as an observer. Often you have discovery disputes that happen during the deposition where you threaten to call up the judge to adjudicate the matter so that you don't have to stop the deposition and pick it up days later. I guess it could be the case where the judge just wants to stick it to the other side, so the judge actually participates in the deposition itself. I have never seen that, but it theoretically could happen.
Young Rudy Baylor, and just on time, too.
Mr. Drummond.
Get this boy some coffee, Tyler.
Jack Underall, Rudy Baylor.
Young lawyer's always a hungry lawyer. All these boys' claims, underwriting...
There must be 100 years of legal experience gathered around the table.
Next to our lovely court record.
My staff has flunked the bar exam 6 times.
Now, Rudy, don't be intimidated by all these boys on this side of the table. I guarantee you get them on a golf course, they fold like a cheap suit.
Jon Voight plays such a great, pompous big law attorney. He's just taking up all the air in the room and he's trying to dominate his opposing counsel. He's just playing such a jerk and it's perfect. God, that is exactly what these older big firm attorneys are likely to do.
I think maybe it's appropriate to start with the corporate designee, Jack Underhall here. Right here.
I don't think so.
I beg your pardon.
Well, you heard me. I wanted to start with Jackie Lemanchik, the claims handler.
I think it's best we start with Mr. Underhall.
All due respect, Mr. Drummond, this is my deposition. I'm going to call these witnesses in the order in which I see fit. So, I'd like to start with Jackie Lemanchik. Maybe we should just go call the judge.
It's a great threat. Perfectly reasonable, too. You can do that.
Get pugilistic this time of the morning.
I'm not meaning to be pugilistic.
We're simply having a little problem with Jackie Lemanchik, this Polish woman.
What sort of problem?
Polish woman, jeez.
She doesn't work here anymore.
Was she fired?
She resigned. She resigned.
Well, where is she now?
Well, she is no longer working for our client, and we can't produce her as a witness, so let's move along.
That's true. If the employee is no longer with the corporation is under no duty to produce that person for a deposition. But you can bet that there was probably some shenanigans that led to that particular person no longer working at this company.
This bugging device has got medium-grade circuitry. It's a weak transmitter. Probably manufactured in Czechoslovakia. I don't think the cops or the feds would place this. Somebody else is listening. Who else would be listening to us? I got a pretty good idea.
So Rudy's office got bugged. For a long time, I thought that would be completely unrealistic. But lately, there have been some law firms that have gotten in really hot water, maybe not for bugging their opponents, but for doing some really shady things. For example, David Boyes hiring an Israeli security firm on behalf of Harvey Weinstein. Nowadays, what used to be something that would only be seen in fiction is actually becoming more realistic. That's a sorry state that we live in.
The judge gave us the names of 92 potential jurors. We investigated their backgrounds, and we rated them with plus or minus numbers.
What do you want me to do? All right, here we go. What?
Any direct contact would, of course, be a serious offense.
What are we doing?
We're gonna do this thing. Just do what I say.
Okay.
Hello?
Yeah, Rudy Baylor, please.
This is Rudy Baylor.
This is Billy Porter. You stopped by the shop today.
Yes, Mr. Porter. Thank you very much for calling back.
What do you want?
Yes, well, it's about the trial, you know, the one you got a jury summons for. I'm one of the lawyers.
Is this legal?
Of course it's legal, Mr. Porter. Just don't go telling anybody.
So at this point, the opposing counsel has bugged Rudy's phone and listened to the false information of him pretending to talk to one of the jury members. And so he's going to try to voir dire the jury and elicit information about this jury tampering that actually didn't happen. Fairly brilliant way to screw with opposing counsel.
Did you, Mr. Porter, or did you not have a phone conversation a few days ago with Mr. Rudy Baylor?
Hell no.
I thought you were gonna give me an honest answer.
I gave you an honest answer.
Are you sure, Mr. Porter?
I'm damn sure.
Mr. Porter, in a courthouse in the United States, in a courthouse of justice, state of Tennessee, I say you did not provide an honest answer.
Don't call me a liar.
Oh, you're a liar, all right.
Son of a...
And the bailiff tackled them.
Bailiff, remove Mr. Porter from this courtroom. Mr. Billy Porter, you are excused from the jury.
Yeah, seems like a good reason to dismiss a juror.
Your Honor, I move to dismiss the entire panel, Your Honor.
Denied.
So Rudy fed them false information, the defense counsel bought it hook, line, and sinker, and they made a fool of themselves, and now the jury probably hates defense counsel. So great job by Rudy under the odd circumstances of having his office and phone bugged by opposing counsel. I don't know if that's the right tactic to have taken. If he had taken that information to the judge, Leo Drummond, the defense counsel, could have been disbarred. And that would really have thrown a wrench into the entire defense.
Please state your name for the record.
Mrs. Marguerite Black.
Now, Mrs. Black, you are the mother of Donnie Ray Black, who recently died of acute myelocytic leukemia because the defendant, great benefit...
Objection. leading.
Yep. Yeah, a common mistake that lawyers make, especially on direct examination, is that they try to fit too much into the question instead of just letting the witness tell their story. On direct examination, the lawyer should just disappear into the background. You're just facilitating the testimony, and you're asking open-ended questions like, what happened? How did that make you feel? What happened next? Can you explain that? And he is asking very leading questions. You shouldn't do that.
You must be stupid, stupid, stupid. Sincerely, Everett Lufkin, Vice President, Claims Department.
Read it again.
Objection. Repetitious, Your Honor.
Sustained.
Correct. Not allowed to do that.
I tender the witness.
Mr. Drummond,
Your Honor. Please remove that exhibit.
Oh man, that is so great. I've actually never seen this in a movie before. It is a common trial tactic to when you have a demonstrative, whether it is a projector or a physical blow up of a document, to leave them up for as long as you possibly can to have the greatest effect on the jury. The experienced trial lawyer, the first thing he does before he begins his cross-examination is he tells the other side to take down his demonstrative. That is possibly the greatest trial detail I think I've ever seen in a movie. It's perfect.
Hi, this is Dex Schiffler. I need to speak to Big Rhino. Can you connect me?
Big Rhino. Just a second.
Okay.
Hello.
Hey, boss, it's Deck.
Oh, hey, Doug. How you doing?
Good, how are you?
Well, I'm cool.
Are you here?
Well, I'm here and there.
Yeah, here and there.
So in the book version, Dex Schifflin actually knows where Bruiser put all of his illegal money, which is a difference between the movie and the book, which I listened to on Audible.
Well, listen, I got a stolen evidence situation.
Okay, stolen evidence, let's see, okay, DeSoto case.
DeSoto?
Carmine DeSoto. You remember him? Club Ruby.
Uh-huh. Where do I find that?
Around 92, you'll find it, let's see, 650 something, Southwest 2nd.
Boss, you're a lifesaver. 92?
Yeah, Club Ruby case.
So that's really funny because what they are talking about is the case citation for a case that apparently has some good authority on using stolen evidence. He said you could find it in 650 something, Southwest 2nd, and then he didn't give a pin site. But what he is talking about is the volume itself, the book of the compendium of cases, all the reported cases, 650 something, in the Southwest 2nd Reporter, which is absolutely the right reporter where you will find all of these cases. That's another thing that you rarely see in legal movies is the correct nomenclature for finding a case citation.
This is the claims manual that was given to me by Jackie LaMancha.
Objection, Your Honor. Stolen work papers inadmissible. You ruled on this.
Sustained.
May we approach?
I thought this matter is already settled, Your Honor.
Your Honor, I just this morning found a case that is controlling in this factual situation.
What do you have?
If you'll just take a look at this rule. It's Club Ruby versus Carmine DeSoto. A copy for Your Honor and one for Mr. Drummond. Number 585 Southwest 2nd, page 431. It was argued by Bruiser, by J. Lyman Stone, and it shows very clearly that stolen documents are in fact admissible if the lawyers played no part in the theft.
Well, according to these head notes, this case will overrule your objection.
Yeah, so the trial court is not bound by its own prior rulings. It can revisit its rulings for the most part. This is a great example of what's called a pocket brief, where you will either take the case or write a quick argument, write it down so that you can provide it to the judge when the need arises. And he has provided this case to the judge to revisit the prior decision on stolen work product. And what the judge mentions, this is such a great detail too. The judge didn't read the actual full case, but he read what he called head notes. Head notes are the summaries that the case databases put at the top of the case, so you don't have to read the entire case itself. It summarizes the relevant law. Such attention to detail. It's incredible.
This case will overrule your objection. Sorry, Leo.
Oh, I'm sure you are, Your Honor. But note my strong objection.
Objection noted.
May I approach?
Oh, and this is another great detail. The stenographer stands up from her desk so that she can take down what is being discussed between the judge and the counsel. Even though it's not being projected over the PA system, she is still taking down the dialogue that's going on because that has to go in the record. I don't think I've ever seen that in a legal movie. It's perfect.
Mr. Keeley, that is a report from Great Benefit's own medical committee, which you chaired. Would you please read from line 18?
Since bone marrow transplants have become standard procedure, Great Benefit would be financially justified in investing in bone marrow clinics.
Approach a witness, Your Honor.
You may.
Thank you. There you go. A little louder.
Objection, Your Honor, repetitious.
Oh my God, that's so good. I think this was done on purpose, and I think it's to show that Rudy is sort of becoming a great trial lawyer. If we rewind it back, in the prior scene, he moves the microphone away with the binder. He kind of nudges it away, making the microphone a little bit further away, so that when the witness reads this incredibly damning statement, it's a little low in volume. He then walks back to the witness stand, moves the microphone towards the witness, and asks that the witness read the statement again because it wasn't picked up the first time. But I think the point there is to show that he moved it away on purpose so that he could get around the normal objection to repetitious testimony. I've seen an attorney essentially do the exact same thing when moving the microphone closer to the witness so that they can say it more clearly for the second time to really hammer home this great evidence. This is amazing. It's amazing. All right, that was The Rainmaker. One of my favorite legal movies of all time, and I'm glad to see that it stands up, but now it's time to give the movie a grade for legal realism. On the one hand, we have a very, very realistic trial. We have trial tactics that not only exist in the real world, but this movie captures nuances that I've just never seen in any other work of legal fiction. On the other side, there are some bits of dramatic license. You have bad lawyers, but frankly, they're bad lawyers within the narrative of the story, so they should be behaving badly. So that actually seems to make sense. All in all, I think this might be the most accurate legal drama that I've ever seen. So I'm giving The Rainmaker an A+. I had no idea it was directed by Francis Ford Coppola. It's just beautiful.
I guess that's it.
Did you know that John Grisham says this movie is the best adaptation of any of his books? It's easy to see why, because this movie is fantastic. But the book is almost as good. I wanted to see what the differences were between the movie and the book, so I prepared for this review by listening to The Rainmaker on Audible. Audible is great because you can read no matter what else you're doing, like responding to improper copyright claims on your YouTube videos.
I need to smoke.
I know you do. We're gonna get to that later.
Audible is giving legal eagles like you a free 30-day trial. All you need to do is go over to audible.com/legaleagle, click the link in the description, or text Legaleagle to 500-500. You can download any audiobook of your choosing, and you'll get 2 Audible Originals for free. Clicking on the link really helps out this channel.
You'd be crazy not to take that.
If you liked The Rainmaker by John Grisham, you will love his other books. He is a very prolific writer, so there are over 30 different John Grisham books available on Audible, including his brand new book, The Reckoning, and classics like The Firm and A Time to Kill. So head over to audible.com/legaleagle or text Legaleagle to 500-500. Do you agree with my grade?
Absolutely.
Leave your objections in the comments, and check out this playlist over here with all of my other Real Lawyer reactions, where I will see you in court.